I see a lot of familiar faces. I see some unfamiliar faces as well. So for those who are new to us, thanks for joining us today. This is going to be a moderated panel followed by a Q&A. So as you get questions throughout, just jot them down, and we'll be sure to save time at the end for the questions. Today I'm pleased to welcome our panelists. I'm going to just give brief introductions for each one of them so that we can move into the panel. So not my usual long bio for each speaker. So directly to my right I have Jessica J. She's the founding partner of Conservation Law, PC, and a 1997 graduate of Vermont Law School with both our JD and our MSEL. And she teaches in our summer program. She's a summer faculty member teaching land conservation law. On the opposite side of the table is Gil Livingston. He's the president of the Vermont Land Trust based in Montpelier. Next to him is Reagan Bissonette. She's the director of easement stewardship at the Society for Protection of New Hampshire Forests. And last but not least, Jeannie McIntyre, president of the Upper Valley Land Trust. So today they're going to be discussing protecting land in perpetuity, the practitioner's perspective for this issue. And please join me in welcoming them.
Thanks, Melissa. So today we do have a unique opportunity to hear from the practitioners in the field who are actually implementing, stewarding, hosting, shepherding the conservation easements that we create to last forever over time through perpetuity. And this opportunity is unique to talk to them because you can imagine the challenges associated with holding an easement, stewarding an easement, and enforcing an easement over time, while at the same time contemplating that there will be changes that occur over time and finding a way to manage those changes and adapt to and address those changes, particularly in light of the fact that the law on these issues is evolving at the same time as our practice area of creating perpetual conservation easements. So our discussion today will be benefited by the fact that we have three very well-respected, some of the oldest, longest, most well-respected organizations in the country holding, not the people, the entities, let me clarify, the people are youthful beyond belief. The entities represented by these folks are some of the more sophisticated organizations doing this, and they're on the forefront of thinking about how to deal with adapting to changing times and changes being requested by the landowners on the properties that are burdened by perpetual conservation easements. There is a handout in the back. It sort of loosely guides our conversation. We're going to have several hypotheticals that are based on real questions that have been posed to these land trust directors. And there's also on the back side of the handout, or the second page of the handout, which you might want to pass around, some of the only guiding case law we have to use in this instance. So we have the Internal Revenue Code, which guides us for deductible donated conservation easements, and we've set out a couple sections of that to guide our thinking as well as our practice. We also have the regulations that accompany that part of the code, a summary statement from the Land Trust Alliance about how the emerging law is guiding us in this area, and then several case summaries, the resolution of which in the last few years and months in some cases has aided and assisted and given us a little bit of a glimpse into how to manage some of these amendment requests that we're going to pose for the Land Trust today. It's essential to note also that Vermont Land Trust practices largely in Vermont.
Only in Vermont.
Only largely in Vermont. Jeannie McIntyre's organization, the Upper Valley Land Trust, is a regional organization that straddles both Vermont and New Hampshire. So looks at these areas of law and these questions under two different state structures, also guided by the federal law. And then Reagan's organization practices and conserves land solely, largely solely in New Hampshire.
We have 3 easements in Maine, and we're looking for someone else who'd like to take them.
Oh, wonderful. So anyone knowing of someone in Maine that wants to take 3 easements, contact Reagan by the end of the session. So what I want to do in terms of the panel discussion is jump right into some questions to get some feedback from these people who are literally in the trenches responding to the telephone calls, the actual requests for amendments and modifications of these perpetual documents, and the ones that when you bring, they're on the other end of the phone having to try to answer these questions. And understanding that hearing from their responses will be guided, and their responses will be guided by perhaps the different states within which they practice, as well as perhaps different approaches within those states or within their own organizations to responding to these requests. But I do want to have the opportunity for each one of them to respond and then give you a chance for questions instead of waiting until the very end, so that we'll hear from each panelist on each question and then open for attendee questions with the permission of the panel. The empty chair represents the Nature Conservancy, who was meant to be representing the national organization accomplishing the same goals on the local level here in both states, who begged out because they actually have a retreat. All of their people in New Hampshire and Vermont are in the same building, not available for this discussion. So that's who the empty chair refers to today. So if everyone's got a handout or can look over someone's shoulders for a handout, we're going to start with a scenario where a conservation easement is held by land trust protecting about 100 acres of 105 acres total for what was an active dairy farm with no subdivision rights retained by the original owner. Successor farmer, meaning the farmer that buys the property from the original grantor, asks from the land trust release and subdivision of the old farmstead, which has obsolete buildings, because she has a different business model for the property, which would not be a dairy and would not need the excess infrastructure to support her ag production on the remainder of the property. The farmer now proposes offering an option of purchase at agricultural value, which is an option that would be held by the land trust and OPAV to the land trust on the conservation easement, or to add the 5 unencumbered acres next door in exchange for the release and subdivision rights, which is sort of a swap of rights. She wants to add 5 acres to the easement and subtract for herself the release and subdivision of the right to develop the farmstead infrastructure in a different way. So we're going to start with a global question of each of the panelists, which is how and why might have your approach to this sort of proposal changed over time, given the context that we set at the beginning of our discussion, which is of the state of the law, the evolving common law under federal statute. Let's start with Gil.
So I think both in the olden days and more recently, we would start with the context, looking at the purposes of the conservation easement. The class of farmland easements that we hold in Vermont, which numbers around 800, are focused on protecting natural resources, but they're equally focused on supporting, assuring the long-term economic viability of enterprises on those farms. So farmland easements in Vermont are focused on the local and state economy, in addition to protecting conservation values. So frankly, until 3-4 years ago, we would have first analyzed whether or not eliminating the complex of buildings was a thoughtful approach, looking not just at short-term needs of the current farmer, but long-term farmability and flexibility on that farm. If we included, in fact, that the buildings were an albatross, not contributing, we would look, I think, pretty favorably on the idea of adding affordability. And without getting into details, I think we've come over the last 10 years, especially to the notion of focusing on long-term affordability of farms so that they stay in farmer ownership, so that they stay in production and continue to meet that second goal around economic viability I described. So I think we would have gone into a detailed conversation about the relative benefits and the values associated with releasing farmstead complex and buildings, and in exchange getting that important attribute of permanent affordability.
Would your approach be different today, given you mentioned the last 3 years or so?
Yeah, so we would not consider an amendment under these circumstances.
And why?
Because of high sensitivity on the part of IRS and other folks in terms of this idea of swaps to begin with. And second, I could talk in more detail, we would sooner look at the opportunity to subdivide, keep conserved, but subdivide and permit the separate sales, separate ownership of the farmstead complex, which isn't a swap, it leaves intact the essential conservation values. You know, frankly, not a very helpful disposition, because in those circumstances, we end up with a small piece, a farmstead complex populated by buildings, which is unlikely to have any measurable conservation value. That is very little natural resource value. So we end up essentially with a conservation easement on a small parcel with a lot of buildings, and we're stewarding, that is maintaining a relationship and dealing with landowner issues in perpetuity for no conservation return. So I think the dynamic has shifted in that regard.
So you mentioned the concern with the IRS and the federal implementation of the law and the evolution really of the case law regarding deductible conservation easements. Is any of your decision-making influenced by the state of the law in Vermont itself, or does Vermont's own situation in its own state enabling act or other laws impact your approach to analyzing this?
So Vermont, I think unlike other jurisdictions, but you know, you can describe this better than I, there's kind of a split theory around how conservation easements are treated. Very clearly under Vermont law, they're property interests. Property interests that can be renegotiated, that is the easement holder, the land trust, has the legal opportunity, legal right to renegotiate terms and conditions of a property interest with the owner of the encumbered fee interest. And we have an elaborate protocol and take a lot of care in doing that. But as a legal principle, there's no Vermont impediment, there are no Vermont standards, there's no Vermont system, there's no set of criteria that affect that. Frankly, we're looking at, we had talked about whether this was an easement that was donated or an easement for which any form of charitable action was taken. I think we would take a much closer look at any easement we received that was donated to us, or where there was a bargain sale, that is a sale at less than fair market value, with there being essentially a mixed benefit to the landowner, cash and a charitable contribution. Those two kinds of transactions would subject us to kind of the IRS regime. And even if it was simply a purchase of a conservation easement, we're still going to be looking carefully at the potential IRS evaluation of our practices with regard to amendments.
And so you touched on the donative value, or maybe the donation component in a full donation, or maybe a partial donation through a bargain sale. But when are you and what are you guided by if there is no donation component? That last sentence you said was, we would still look closely and be concerned with, and where are you having a duty in that context?
So again,
when it's not under 170H.
Understood. There, to my knowledge, is no assistance, legal assistance in terms of precedent, the regulations of the IRS or otherwise. The Land Trust Alliance, which is the membership organization of land trusts across America, has spent a good deal of time focusing on amendments. Produced a compendium, a thoughtful compendium about easement amendments, I think in 2007. And within that compendium are 7 specific guidelines. Without going through them, they're guidelines that we followed previously. But essentially, we marched through the set of standards around donative intent, around connecting with the donor before doing amendments, around private benefits, around complying with state and federal law. We marched through that analysis, whether or not they apply. And frankly, land trusts being nonprofit organizations file a 990 tax return, right? We don't pay taxes, but we have to file an annual return starting, help me, 3 years ago. that form added a requirement for land trusts that hold conservation easements, added a requirement of attaching a schedule that identifies and describes any easement amendments of any sort. As far as I know, the IRS has done nothing with that information, but the fact that they're curious means that we, for additional reasons, take care in what easement amendments we do, what the benefits are, and abiding by those LTA standards.
Thank you. Let's travel to New Hampshire, to the New Hampshire Society of Protection of New Hampshire's Forests, and ask Reagan the same question in terms of how, and if so, why might your approach to this sort of proposal changed over time? What would your approach be and how might it have changed?
Right. So the Forest Society has about 700 conservation easements, and although none of them are specifically agricultural easements, we are finding that actually our easements that are on farms are some of the most challenging issues we're facing right now related to requests for amendments. So this is something we've spent a fair amount of time talking about internally. When it comes to swaps in general, it used to be that we would consider swaps in various forms really only in the past to resolve a violation to an easement. So in a situation like this 5 years ago, I don't think we really would have considered the possibility of extinguishing part of the easement on this property. Farm viability, for better or for worse, does not factor into our analysis. As an organization, we do want to support farmers, but that's not why our easements are created. And I do recall, maybe it was last year, the year before, Karen Gross, the senior attorney for the IRS Charitable Deductions Unit, was actually here speaking, and someone asked about farms and agriculture, and she specifically pointed out that nowhere in the tax deduction code does it say anything about protecting farm viability, which is sort of an interesting challenge. So in the past, and today, the Forest Society likely would not have seriously considered this request. Today, in particular, we are very leery of anything considered a swap. We won't touch anything that involves the termination of a conservation easement in whole or certainly not in part. That's mostly due to the Belk case, which is one of the important cases in the handout. Even though that case specifically deals with conservation easements that have language in them permitting swaps, our outside counsel has advised us that we should really be cautious about anything that could possibly involve a partial termination of a conservation easement. So at this point, really, the only time we would allow for any tiny amount of a conservation easement to be terminated would be in with regard to a violation, say it's some structure that's just over the boundary. We might consider a small, teeny tiny swap to resolve that issue, but certainly we would not consider an amount of space to remove buildings out of a conservation easement.
So if you did contemplate the swap or what you might deem a partial termination of that easement, meaning it's released from the easement in exchange for something else, what would be the process you would undertake in New Hampshire in contrast to Vermont?
So in New Hampshire, the Forest Society is a Land Trust Alliance accredited organization. So we actually have sort of 4 areas of guidance that we think about when we're considering an amendment to a conservation easement. So one is the guidance from LTA, because we do have to follow that set of principles when considering a conservation easement amendment. That is worked into the second document that we think about, which is the Forest Society's amendment policy. We have a very detailed policy outlining all the different factors we consider when determining whether to amend an easement, and that encompasses the LTA's requirements. We also have, of course, IRS considerations, and so Belk is certainly a concern, but also in general, the concern about private benefit. So even if it's a conservation easement that we purchased fully, and so there was no tax deduction, we're still very concerned about our 501c3 status, and no nonprofit cannot convey any kind of financial benefit to another party. So if we are thinking about doing, say, this type of swap, if we were going to consider it, we'd be requiring usually an appraisal, which tends to be quite expensive, but an appraiser to come in and identify what is the financial value that we would be conveying to a landowner, and then what are they giving up of financial value to sort of even out that transaction. And that can get rather challenging. And then the last factor, of course, is the New Hampshire's guidance for amending conservation easements. So unlike Vermont, we do have a very detailed process in New Hampshire for how conservation easements can be amended, because conservation easements in New Hampshire, whether they are donated or not, are considered, they're almost always considered charitable trusts. And that means that the Attorney General's office, their charitable trust unit, has determined that conservation easements are not just a private contract between the land trust and a landowner, but there's also a third party in the room, and that's the public. And so the Attorney General's office is representing the public's interest. So anytime we're considering an amendment to a conservation easement, we have to go through a review process with the Attorney General's office. And depending on the type of amendment, depends on how thorough that review process is.
Wonderful. Let's hear from Jeannie in terms of what the approach might be of the Upper Valley Land Trust in assessing and how that might have changed in current years.
Right. So for us, the answer is similar to Reagan's. We've had amendment policy and approval policies for 25 years or so, and they really haven't, the policies haven't changed much at all. The experience with the kinds of questions that we get and the problems that arise for landowners and for the public as a result of our drafting decisions have led us to draft easements differently over the last 25 years, 25, 30 years. But I don't think the approach that we take to responding to these requests has really changed that much at all. And you know, we would look at this request as something that there's no ability from inside the easement to, that we have no authority to approve it. It is an amendment request. It would not comply with the criteria of our amendment policy, and we would say no. I think, you know, notwithstanding the goals of farm viability, our organization undertakes agricultural conservation to prevent conversion and fragmentation of resources. We are in a region that has very dynamic agriculture, a lot of different ventures coming and going. This type of request to describe building complexes as obsolete and release them from easements is one half of a cycle. The other half is the desire to build new buildings that seem current at the time we get those requests. When you take that cycle out over 400 or 500 years, you end up with the fragmentation of agricultural resources and the diminishment of the values that we undertake to protect when we start into these types of agreements. So, you know, just sort of philosophically and taking a long view of perpetuity, we're somewhat hesitant about, you know, we understand the reasons that people bring these kind of requests forward, but we think of them against a sort of a tableau of perpetuity, which is, you know, business ventures come and go as well. And our goal is to protect the conversion and the fragmentation of these resources.
So Jeannie, you mentioned your drafting practices over the last 25 years or so. Have those practices changed in response to the evolving law and the approaches of the AG in New Hampshire? And more specifically, do you include an amendment clause that anticipates a request for an amendment? And if so, does that change your approach to the, you know, the process?
So the first thing one thing that has certainly changed is that our easements now almost always are drafted so that a subdivision could be approved with the permission of the land trust, and then often with defined criteria for when that such an approval could be allowed. So because we get in situations where there are these very minor changes, or there might be a reason, for instance, so we describe extraordinary circumstances. One extraordinary circumstance is a public ownership takes place next door to a large piece of property we've conserved, and that public entity wants to own part of our conserved land in order to provide a trail or some other kind of public benefit. And there's no reason that our conservation land shouldn't be subdivided. With an easement that says no subdivision, there is no subdivision permitted. That's kind of the end of the discussion. So we have added some flexibility for us to exercise some discretion in limited circumstances. We do now have an amendment clause in our conservation easement template as a standard. We have some funding sources that don't like it, there are ongoing discussions with state and federal agencies about why you have these things and why you don't. But in New Hampshire, conservation easements are asserted by the AG's office to constitute charitable trusts. The procedures for changing charitable trusts are very different if you have an amendment clause in your easement and if you don't. And so in order to make it clear to the AG's office that all the parties understand at the outset of a conservation easement that there might be some circumstances, and they're in our provision, they're very circumscribed. But we want to make it clear that we understand that there are some circumstances under which an easement could be changed, and that under those circumstances, changing the easement is not a violation of the charitable trust.
So for the two of you that hold easements in New Hampshire, how has the process been for you of the amendments that you have endeavored to approve in terms of submitting those to the Attorney General and that process that unfolds after that point? Have you had a great experience, meaning large amount of experience, or limited, and how has it gone once it's in the AG's hands?
For us, I believe we've submitted 3. 2 of them were very straightforward, and they were reviewed, I believe, within about 6 or 8 weeks. It was a simple matter of sending maps and a sort of executive summary of what issues were driving the request. They were the kinds of, they weren't violation related, but they were the kind of teeny tiny things that Reagan was describing. The other was an approval request that we thought had the effect of an amendment.
Okay.
So it was a state agency that did not want to condemn a slope where they wanted to rebuild a road, and they were wanting the landowner to grant a slope easement to them. And the easement said we had the ability to approve additional easements, but we knew that if we approved it, it was subordinating our conservation interest to the state's interest in the slope easement. And so although the construction of the slope by the state was actually going to improve the land that this landowner had, make it more useful for farming, and straighten out some erosion problems. So from an ecological standpoint and a natural resource standpoint, there were some benefits to it, but we wanted the AG's office to help us get clear that this approval that we thought had the effect of reducing our rights to the protected property was acceptable. And that took a little bit longer because it was a little bit unusual. I think it was probably 8 or 10 weeks it took them to review, with a couple of conference calls. And the big discussion was about whether the state needed to provide some compensation for the rights that they were acquiring, even though it wasn't a condemnation action.
Right. Reagan, any input on the easements that have flowed through that AG review process?
Right, because the AG review process has been in place in New Hampshire for about since 2010, I believe it was. And since that time, the Forest Society has probably done over a dozen amendments. But I should clarify that Amendments are also considered in New Hampshire to include additions to existing conservation easements. So the vast majority of the amendments the Forest Society has done has simply been to add on existing land to an existing easement. So when we're talking about sort of more substantive amendments that the Attorney General's office might actually be worried about, they have 3 levels of reviews. There's low-risk amendments, and that would be adding land to an existing easement. Also correcting Scrivener's errors, which unfortunately happen a lot more often than I would like, but when you're hurrying to protect land, sometimes you end up with property descriptions that are a little offbeat. So those are all low risk and very easy to send in information to the Attorney General's office and get a response within, I would say easily within 6 weeks. More risk amendments are sort of the middle level, and those are usually would involve trade-offs. So something that you might have considered a swap. Basically, if you're maybe going to add land to the easement, but then you're also going to give up a restriction. So those types of trade-offs require much more thorough review by the Attorney General's office, and we've done 2 of those actually in the past 2 years since I've been at the Forest Society. And in that case, we've gone and actually met personally with the director and assistant director of that unit, had conversations with them in advance to ascertain what their level of concern was before we moved through a process with a landowner, which would involve a legal review of the request and also maybe getting an appraisal done. And then once we have that whole package of information, we go back to the Attorney General's office again. So those took months, but only because not so much the Attorney General's office was slow, but because the process of amending a conservation easement in any kind of substantive way can take many, many months.
So in the interest of time, I want to summarize that was 3 no's, in case you're keeping track. No, no, and no. 3 resounding panel unanimous no on the first proposal. Before we suspend for a moment of questions from the attendees, let's just look quickly at the next example and get some feedback, starting with Gil. This now doesn't involve a swap. We've now got the farmer saying, hi there, land trust, I need to check in with you because I don't have sufficient allowance for employee housing on my conservation easement. I have a limitation to single family unit dwellings within the easement property, and I need to build some bunkhouse style housing for employees to be hosted on my property, which needs this type of employee support in order to continue to be a viable agricultural working landscape in Vermont. So Gil, how do you respond to that request and maybe contrast with the first response?
Yeah, so I regard this one as qualitatively and legally different. And not to repeat, we're focused on long-term viability, economic and conservation viability of farms that we conserve. I think first we'd ask whether it was a donated or bargain sold easement as just background information in terms of the care and focus on IRS criteria as we evaluate this. Second, we wouldn't permit the activity, the construction of additional housing without an amendment of an easement, so we would be tracking the 7 LTA principles. Third, we've actually done this. The value associated with adding, especially bunk-style housing, that additional benefit. Reagan talked about the importance of focusing on conferring private benefit without public benefit sitting alongside it. The additional value in our experience is very modest, but it's measurable. So in each of these circumstances, we're going to be looking for something in exchange, a substantial public benefit coming in our direction, which could be additional substantial cropland. It could be the release of existing rights. I mean, it may be the farmers reserve the right to build another single-family residence for family members, so looking to extinguish that right in exchange for adding housing. The other thing we do is, and we've talked about this already, adding affordability to a first-generation easement that doesn't have affordability. But conservation biology has also evolved over the 40 years in which we've been doing farmland transactions. So we look very, very rigorously with 2 conservation biologists on staff. We look at surface water attributes, natural community attributes, and we'll often enhance an easement. One other way in which we can get some public exchange is to take a fresh look natural resource conservation protection in the easement, and enhance it in a fashion that respects that current knowledge. Despite the fact the easement clearly, in this case, says no residential units, the goal around that language, as originally authored, was to prohibit the proliferation of single-family residences in a fashion that wasn't in service to long-term farm viability. If you can imagine multiple large, modest-sized houses, upon transfer, the value of that farm is going to be driven up by those residences. So we would craft an approval in this circumstance that capped the size and capped the use and occupancy, so that there was a direct nexus with farm operating needs, near term and long term. We would prevent, unlike most easements with a single family residence, we would manage occupancy that is limited to people who are living and working on the farm, and often cap size scale. Yeah, so I think that's the way we'd approach it.
Right, and can you offer if you would approach it differently, and or how your answer might be shaped by the process in New Hampshire, if it were in New Hampshire?
Right. So we actually would go through a similar analysis as Gil was describing, but one of the things I'd add on is that, and actually, so the Forest Society, we wouldn't have language really, we don't typically have language specific to what type of housing is permitted. We would typically
She's accepting herself from the question.
we generally carve out an exclusion area in which the landowner can do whatever they want, so we don't have to get involved in their buildings. But if we did have this type of language in one of our easements, I think one thing that would lead us to consider this request is that the way this is drafted, it clearly shows an intent to allow some type of farm-related housing, employee housing to be developed within existing buildings. So at least that donor intent would be really important for us in our analysis as to whether we'd consider it. The one piece I wanted to flesh out a bit is that when we're thinking about what type of improvement, enhancement needs to be made to the easement in order to allow something like this, we're thinking about it in two parts. Both, there needs to be, at the very least, a net neutral effect on conservation attributes. So you talk about bringing a soil biologist, encouraging, just ensuring that there isn't going to be a detriment to the natural resources that are being protected on the easement. But the other piece is that we'd also look carefully to make sure that a financial private benefit is not being conveyed. And so in a situation like this, we probably would actually require an appraisal. And so we'd have both the appraisal, and then you also have to have some kind of ecological benefit to the property. And what that can sometimes result in is a bit of a perverse situation where land that can be very valuable to, say, add to the easement for conservation attribute reasons may not have a lot of financial value to add to the conservation easement. And so we have run into a situation where we had to have sort of two pieces of land added to an easement. One was developable land that had a financial value that our appraiser could look at to say that we weren't conveying a financial benefit, and then the other piece of land actually had a lot of great natural resources. So it can end up having kind of some perverse effects when you're trying to ensure that you're not conveying a financial benefit to a landowner that the IRS would not like to see.
And Jeannie, if that was happening in New Hampshire, any distinctions you might draw, or just share with us what that process might look like?
I guess the one thing that I haven't heard from my colleagues that occurred to me when I read this description is that the drafting of this paragraph is a little odd, and there's a lot of loopholes in it. And I think that for us, one early piece of the analysis would be to go back through our files as best we could and try to understand what the intentions of all of the parties were at the time this thing was put together. Was single-family residence just in there as a term of art, or did the parties really mean to expressly forbid any other kind of residential setup? Does the reference to putting housing in existing buildings mean the buildings that were in place at the moment the easement was signed, or does it mean any farm building that's constructed later? I think, was there any natural resource or public benefit reason why there was a strong preference for housing being in those buildings as opposed to anywhere else on the property? I think the answers to all of those questions would help us figure out if we could go in the direction that Gil and Reagan have suggested. I can imagine a land trust concluding that the construction of a bunkhouse, new construction of a bunkhouse, isn't materially different than building a shed and 3 years later converting the shed to a bunkhouse. And if that is the kind of opening that one finds when one analyzes the baseline documentation and the correspondence and the appraisal that all were part of this original package, then I can picture that a land trust might think about the size, the scale, the location, seasonality, employment relationship, and get to a place where approving a bunkhouse might, in some circumstances, not be unreasonable.
Okay, so we're gonna engage in the speed round and then open for questions. Just to slip one more question under the gun here. Same property, successor farmer is proposing adding an unforeseen, arguably not permitted commercial use that's not in furtherance of the agricultural use of the property. In fact, is a commercial Nordic skiing operation in order to increase the income that the property makes, but that is not agricultural. So rapid response, starting with Gil, yay, nay, and where do you go?
Yes, conditionally. Again, most farms, vast majority of farms in Vermont rely on off-farm income or ancillary non-agricultural income as a basic principle. Second, this would be a much harder question if new structures or substantial physical disruption is going to occur. It strikes me the disruption is largely going to be around vehicle traffic, but our easement doesn't manage vehicle traffic on a conventional farm to begin with, so the relatively, strikes me, very, very seasonal, non-intrusive use, and especially engaging the public in direct contact with operating farms in Vermont. Public access being one of the acknowledged IRS purposes for conservation easements, strikes me this is easier than the previous two we've talked about.
Thanks. Reagan?
I basically agree with Gil. Landowner intent would be an important one for us. Is there any reason why commercial cross-country skiing would not be something that the original grantor would have intended? This actually is one of our real examples, and in that case it was actually, there was a long history of cross-country skiing on this property among the family of the grantor. Also an appraisal would be required, and then in terms of considering what the impacts would be, in this case we actually are working on a very detailed commercial recreation management plan that will have to be in place before a handful of small structures could be built, and also to ensure that trails would be maintained in a proper manner. But in our case, the conservation easement allows for extensive trail networks anyway for forestry, for example. So that impact is already permitted on the property.
Jeannie, final words and conclusions?
Yeah, I think this one is hard. I think that we have in our heads that cross-country skiing is benign, and it is at certain scales, but cross-country skiing in our region includes snowmaking, and includes some very potentially disrupting activities as well, and also I think there's a lot of learning going on about the effect of trails in forests and forest health, habitat, light on the forest floor, and that sort of thing. And so if we were going to consider an approval, the scale and the management plan would be very, very important. I think, frankly, the likelihood that commercial cross-country ski activity is going to be significant from a farm viability standpoint and yet be benign on the conservation resource standpoint is not that strong. There might be great reasons to have these two things co-located, and we're actually working on a conservation project now that where they are, so they're not incompatible, but bringing it in as a commercial use to provide financial support for a farm operation at a level that would be meaningful. I think the business planning side of it would be as interesting as the management planning side, conservation-wise.
All right, so let's open for questions from the attendees, and if there's resounding silence and no questions, we'll pose the final question to the panelists. John?
So I understand that one can come up with all sorts of hypothetical situations where an amendment seems like an appealing thing to do. And if you have additional flexibility to consider such amendments, you can imagine situations where you can do conservation good. But I guess my question for you would be, if the law were different, and if as some apparently are now proposing the federal statute were modified, and if state law were different, and land trusts had as much latitude as some would like to entertain amendments, I'm curious what problems, if any, you might see in that scenario, both for the way in which you do business and for the donors who contribute conservation easements and for the general public that is served by your organizations.
I would point out that the first hypothetical, they all said, no, we can't imagine to do that. They didn't imagine a way around that one. So,
Should I take a stab?
yeah, please go.
So great, complicated question. You never posed a question to me about whether or not we have amendment clauses in our easement. Like Jeannie, we've only recently done that. The reason we don't have them is because we don't invite them. We don't want to engage in that practice. So that's one principle. I've already said flexibility in the context of people-connected land conservation is important, especially when there's a business enterprise. So distinguishing between natural area protection, riparian protection, wilderness protection, and people access recreational conservation, working lands, working forest conservation, they're kind of different things. Frankly, this is an area of work that has few rewards, except in the circumstance that Reagan talked about, which is our experience. The vast majority of easement amendments are enhancing. They're adding more land, they're providing more environmental protection, they're extinguishing rights. I frankly don't envision us as an organization changing our practices if there's a more open invitation, because we're still very focused on the original donors' expectations as well as the conservation purposes in the easement.
I think it's actually a good thing in New Hampshire that, in particular, that we have such an onerous process to go through to amend a conservation easement in a substantive way, not just adding land or correcting a Scrivener's error, but actually a substantive amendment, because amendments are extremely time intensive for staff. They're very expensive in terms of legal costs and other requirements, and we do want to consider that you don't want to make an amendment for some short-term thing that, 100 years from now, you're going to wish you didn't bother. So I actually think that even if it was easier to do conservation easement amendments, we would not be jumping forward to do that. We prefer to keep our substantive amendments very small in number.
I think that there are always going to be different groups that answer these questions differently, and the more the wider the range of possibilities, the more diversity there's going to be in how groups respond. And when there is diversity, some landowner donors are going to find that helpful because they can interview groups and understand policies and pick the approach that works for them. And others are going to find it frightening because they're going to be examples of things happening to supposedly conserved properties that aren't what they would like to have happen to theirs. So I think, there's a pros and cons. I think that right now, the IRS at times has implied that amendments of any sort are incompatible with the current regs. And as an organization working in New Hampshire, where we have a robust AG review process, and you know, have found ourselves in situations where these very, very minor adjustments need to be made, and they definitely serve the public interest. It would be desirable to have some clarification from the IRS that in certain limited situations, following really, you know, careful principles, at least the addition of the amendment of an easement to add land must be permissible. You don't need to have a second separate easement for an adjoining piece of property in the same ownership. So I don't think that a proposal to acknowledge amendments within the regs is bad, although I do think it one has to be careful about how such a thing would be done. There's a lot of references to net benefits. Everybody nets things differently and uses criteria inside and outside of the four corners of the easement. I think there needs to be a lot of discussion about that sort of thing before the IRS makes changes. I would also say for our organization, we believe that whether or not our easements are a charitable trust, they are a restricted gift from the landowner. And we take that very, very seriously. And so, you know, we understand our easement documents to be both real estate contracts, charitable instruments. We're a charity. We have responsibilities to act exclusively for our conservation and charitable purposes. And so that's going to constrain our behavior as an organization. I don't think that what the IRS does is going to particularly change that, but I do think it would change the context we're operating in.
I have a couple of questions. The first one has to do with the cross-country skiing issue. It happens that I have conserved a farm, and I have also put some of it into an OPAB situation. Had I donated the entire farm to Vermont Land Trust, there would be some beautiful cross-country trails on that. And I conserved it for wildlife. And I just want to know how the donor of such a thing would be protected from a decision on the land or the land trust to use the land differently when the owner has title to it.
I can speak to the Forest Society's amendment policy, and I believe it's also derived from the Land Trust Alliance standards for amendments, is that we actually need to document donor intent when we're considering any amendment to a conservation easement. So if the donor is still alive, we would reach out to them and request their written approval of the proposed amendment. In the case of the cross-country ski situation for us, the original grantor was not alive, but we spoke with the family. We spoke with children of that grantor and basically got.
You said that it was accustomed to do it on that land.
Right. It was very fact specific in that case. And so donor intent is very important when we're considering something like this. Also, if we have any direct funders to a purchased easement, another requirement of ours is that we would actually reach out and request a written approval of an amendment that we're considering. So that is a very important point when we're considering an amendment to a conservation easement. It's very fact specific.
I think this is also an example of how our drafting and our documentation procedures have evolved as we've learned about this type of question that we're likely to get. I think it's fairly common that a project manager for a land trust is going to be sitting with a donor and saying, there are commercial activities that a future landowner might want to engage in on your property that are not directly related to agriculture and forestry, but could be practiced without degrading the natural resources. Cell towers, solar and wind, recreational activities are some examples. And trying to anticipate, trying to document how the donor feels about those things and what the landowners, what the land trust yardstick is going to be used in figuring those kinds of questions out in the future. If you can do that as the conveyance is being put together, that is the best
like a great spot to end.
Yeah, we do need to release the students and let everyone go to their next sessions. Thank you so much. If you have other questions, I encourage you to come forward and maybe the panelists can help answer some of those. Thank you.